Let's go ahead and get started. My name is John Finch. I'm the director of Able United. It's the pleasure of me to have David Lillysand and Thomas Nurse. David Lillysand is a partner at Lillysand and Associates PA with offices in Miami and Clearwater and represents clients in Social Security disability appeals, supplemental security income claims, Medicaid, and other public benefit financial planning. He assists individuals and their families in maintaining eligibility through special needs trust. David also provides training to banks on the administration of special needs trusts and is a frequent lecturer on SSI, Medicaid, and special needs trusts at law schools, continuing legal education programs, and community organizations assisting parents of individuals and with children and adults with disabilities. Also with me is Thomas Nurse. Thomas is a partner at Manning & Nurse, personal financial advisors to families with special needs based out of Tampa. He helps individuals and families with special needs to create financial plans specific to their needs. With more than 20 years of experience, Thomas regularly provides workshops and trainings for organizations and advocates and is involved in many committees and task forces on a variety of disability issues. Tom has real-world experience as being a husband, father, caregiver, and advocate in a family with special needs. So we're going to go through a quick overview of the program of Able United, and then we'll turn the mic over to David to go through some of the legal aspects, and then Tom will cover financial aspects. If you have questions at any time, please use the question panel, as that is the best way to ask your questions. So what is Able United? Able United is a tax-free savings and investment account to support disability expenses while maintaining federal benefits. The program here in Florida launched July 1st. To enroll in an Able United account, an individual must be a Florida resident at the time of their application and have a qualifying disability that occurred or onset prior to age 26. So we're going to highlight just real quickly, how do you open one of these accounts? The Able United program is completely online. You open an account online. It takes about 15 minutes. There's no documents or approval process. You self-certify that person is eligible to open an account and provide some additional information. You can fund the account. You contribute up to $14,000 per year, and that's from any source. So family, friends, organizations can contribute money on your behalf into an Able account and then not count as income. When you contribute, you also, this is an investment and savings account, so you want to choose your investment option. We have 7 investment options. 3 are pre-designed portfolios that are designed to meet the needs of most investors, or you can create your own out of the 4 underlying fund options. We have a money market account option, a U.S. bond, a U.S. stock option, and an international stock option. So after your money is sitting in an account and it grows and you want to withdraw it, you can withdraw it anytime and for any reason. And you would do so through an electronic transfer into a checking or savings account, or you can request a third-party check. And as long as you use these funds appropriately, the tax or the gains on the account will not be taxed as long as you use it for qualified expenses. Another huge benefit of the Able United program and the Able Act is individuals are able to keep their federal benefits. You can save up to $100,000 in an Able account and not count towards your asset limit for SSI, and you can even save more while keeping Medicaid. Generally, funds in or withdrawn from an Able account are disregarded when determining benefits eligibility. There are a couple exceptions for individuals on supplemental security income. Once again, the account balance can, the first $100,000 is disregarded, and this is just for SSI benefits. And then also, if distributions are used for housing or non-qualified disability expenses, or they're retained from the prior month for those types of expenses, it could count as an asset and negatively impact your SSI. Individual is receiving Medicaid when they have a Able United account, that these accounts are subjected to Medicaid payback. It's a little bit different than other special needs trusts, which David would speak of, but Medicaid would have to make a claim on the account after all outstanding qualified disability expenses are paid for. And then we'll talk about fees real fast. So Just like a Roth IRA, withdrawals used for qualified disability expenses have no penalty. Funds can be used for a variety of expenses: housing, education, assistive technology, health, employment, and much more. Funds contributed into an ABLE account don't reduce earned income, but they do shelter your assets. You keep account if not receiving public benefits, so you don't have to be receiving public benefits in order to open an ABLE account. There's no application fee or minimum to contribute, and starting in July of next year, there will be a $2.50 monthly account fee. That's currently being waived. There's also an investment administrator fee up to 0.29%. That's annualized to the account balance, and it varies depending on the investment option. So those fees are net of returns, and it's usually less than $3 per year per $1,000 invested in the account. So that's very high level about Able United. For more additional information about Able United, you can visit our website, ableunited.com, to get more of the basics, as well as view prior webinars. This webinar is also being recorded and will be available online, hopefully by the end of the week. With that in mind, I will now turn this over to David Lillison, who's going to give you a legal perspective about the Able accounts. David?
Thank you. It's my pleasure to participate in this webinar because this is one of the most exciting things that has happened to benefit the lives of persons with disabilities, both children and adults. And it's a great first step for our country and particularly for our state. I think we're one of only 4 states to date that have started the ABLE account as quickly as we have. The important thing to kind of understand about what we're going to talk about is the difference between special needs trusts and the types of special needs trusts and the ABLE account. Before we get to that, I just wanted to mention that if any one of us listening to this program who's employed and been working for 10 years gets disabled, we apply to Social Security, and our Social Security taxes have been put into 3 separate trust funds. Everybody thinks it goes into a retirement fund, but it also goes into a disability fund and into the Medicare fund, so that if we qualify for the benefits either by being elderly or by being disabled before our retirement age, then we can draw on those funds. Those funds are not subject to any kind of means testing. Those are prepaid insurance benefits. What we're going to be talking about is Supplemental Security Income, SSI, which is a welfare component. SSI pays a monthly check to individuals who qualify, who are disabled under the Social Security rules, and secondly, have low income and few resources. One of the ways that then we can deal with those issues, because the resource limit, and Social Security calls assets resources, so we'll be using that term throughout the lecture today. But one of the reasons that we get into special needs trusts at all and look for other safe harbors like the ABLE accounts is because the resource limit, the most you can have on SSI, is $2,000. If they don't count a home of any value, one vehicle, etc. But if you've got a small inheritance or even a large one or a personal injury award, you stand to lose not only your SSI check but also your Medicaid benefits, because in the state of Florida we tie receipt of at least $1 of SSI triggers your Medicaid. The difference between Medicaid and Medicare, and the way I thought of it is Medicare, we care for our elderly like our grandparents. Medicaid is an aid program. It's a welfare program, so it has means testing. One of the principal ways that was devised before ABLE came along was to create special needs trusts. This was done by Congress in 1993, and there are 2 types of trusts. There's a first-party trust and a third-party trust, so that you don't mistake which is which. It's really a question of whose money it is. We think of the first party as the person with disabilities. The second party is the government. The third party is you and me and everybody else in the world. So in a first-party trust, the individual has received an inheritance or received a personal injury award, and now we have to do something to maintain their benefits, particularly medical care. Versus a third-party trust, we're dealing with other people's money. So grandma can leave money for her grandchild who's disabled, and she would do that through a third-party trust. But special needs trusts the first party types come in 2 different flavors. individual special needs trust, where I draft a special needs trust particularly for this client, and the document provides only for this particular client, versus a pooled special needs trust, which just requires us to join a nonprofit's already existing pooled special needs trust, so that's appropriate for small amounts. So here's a little summary of first versus third, and I think this helps if people, in analyzing a new matter coming into their office and they're trying to help somebody, whose money is it? And then you track what are the requirements. The primary difference between a first party and a third party trust is there's no Medicaid payback with a third party trust. So if grandma creates a trust for a grandson uses the money during his lifetime. When he dies, whoever grandma designated to receive whatever's left, that's where it goes, and there's no Medicaid payback. That's not the case with first-party trusts. With a first-party trust, there's always a Medicaid payback. All right, so what are the similarities then between ABLE accounts and special needs trusts? Well, both have their origins in federal statutes, so we can all read what the rules are and what the statute says and what the regulations say. Both, the limit that we've had is that we've got a $2,000 resource limit, but both the ABLE accounts and the special needs trust can go above that limit. The ABLE account can go up to $100,000 to keep your SSI benefits and more for Medicaid, whereas the special needs trust, I have one that is holding $12 million for a person on SSI and Medicaid. Similarly, third-party deposits are not counted as income to an SSI individual, but if the SSI individual has this personal injury award that came to him, it's counted first as income in the month received, and if retained to the first of the following month, becomes a countable asset. So if you receive a $50,000 personal injury award, it's $50,000 of income in the month of November. If you hang on to it as of December, and you become over income for this month, if you hang on to it on December 1st, it's counted as a resource and could be eliminate eligibility unless you do something with it. With both programs, another similarity, there's no need to secure advance approval from Social Security or from Medicaid to make a distribution. And the IRS does not require that you secure approval from them for distributions either. Medicaid paybacks required both in special needs trusts and ABLE accounts, and federal and state agencies are in the process of rewriting their rules to accommodate these safe harbor provisions. Safe harbor being where you can put your money and it doesn't count. For special needs trusts, those rules have been written for SSI and Medicaid, but there are 9 other federal programs that are protected by using an ABLE account. That's not true for a special needs trust account, but the agencies are going to have to write rules to make that happen. There are 16 differences between ABLE accounts and special needs trusts, and I want to go through them. Let me point out at this point that in the handouts, one of the things that I put available to everybody is an ABLE account CLE-Lillisand as a handout. It's a 12-page outline with all the citations to the IRS rules, the Social Security rules, and Medicaid rules, anything that you need, and the state statutes that created the ABLE accounts, so that you can see for yourself how it works. And it's going to explain in more detail than what we can do in a webinar with a PowerPoint. So the 16 differences between them. The best one of all, number one, is that the disabled person has control of and direct access to funds in the account. If that's with an ABLE account. With a special needs trust, you have to name a trustee. That's a third party. So if the person with disabilities wants or needs something, they have to go beg, please, will you spend the money so I can have this service or this product or in some other thing that they may be looking for. There's no person between the client and his money with an ABLE account. With the item 2, the shortened time frame for expenses in the Medicaid lien. On death, the account for a special needs trust is frozen, and the repayment to Medicaid is for all time, going back to even before the accident or the inheritance came. It could potentially go back to birth. and the lien is then composed of a really large number compared to ABLE accounts where the lien is only for Medicaid services that were provided to the individual after the establishment of the account. There's another huge difference in number 3 here, payments which are allowed after death. With the ABLE accounts, they can handle bills such as guardian fees that were not yet paid prior to the death of the individual, and any other expenses to wrap up the account, and then the Medicaid lien applies. With special needs trust, the account's frozen, and if that guardian, professional guardian, didn't submit a bill before, Medicaid's going to get paid first and probably wipe out, in many cases, what's left in the trust at the time of death. A huge difference in number 4 here between ABLE accounts and special needs trusts. Specifically by law, the funeral and burial expenses can be paid from an ABLE account, but cannot be paid specifically by law from a special needs trust account until Medicaid is paid off. So we often have the situation where the Medicaid lien is on a special needs trust is larger than what's left. We have to give away all the money and there's nothing left to bury the person. Number 5, age limit, 65 is removed with ABLE accounts. I put a person who was 68 into an ABLE account. I had to show that he was disabled prior to age 26, but he always had been. With a special needs trust, I can't create a special needs trust for a person over age 65 and retain SSI benefits. Huge difference with number 6, ABLE accounts protect food stamp eligibility, Section 8, and 7 other programs in addition to SSI and Medicaid. Number 7 is a big issue. When lawyers create special needs trusts for an individual, they have to submit these to the Social Security Administration, whose staff is variously trained extremely well to extremely poorly, and we get a lot of denials of special needs trusts. It doesn't happen with an ABLE account. It's already been pre-approved. Special needs practice, number 8, no drafting required to place funds in an ABLE account, and you don't need a lawyer. You can just place the funds directly online, as John was just describing. With a special needs trust, if it's an individual trust, you're definitely going to need a lawyer, and even with a pooled trust, you may need some legal assistance to complete the documents necessary to join. Number 9, we've had a number of states that have tried to interfere in the creation of special needs trusts. That is not happening with ABLE accounts at all. Number 10, it's really costly to create a special needs trust. I mean, the average fee is between $5,000 and $7,500 to create a individual special needs trust. And then you have trustee fees, investment fees, setup fees, ongoing fees. The ABLE account fees are so incredibly low, it's hardly worth speaking about. It's less than a monthly cell phone bill for sure, even after the July 2017 period begins, where you have to pay the $2.50 per month to have the account. Number 11, super easy for a person who's been a court-appointed legal guardian to open up the ABLE account as a safe harbor, because specifically by statute, again referred to in the materials that I gave you in writing that you can download, the guardian has the authority to open up the ABLE account, doesn't need a court order to do so. The guardian does need a court order if they're going to do a special needs trust. That's a significant difference, and of course then that adds costs and time. Number 12, special needs trusts, you can have multiple special needs trusts. You can have, no limit, 2 of them, 3 of them, 4 of them, 5 of them. The ABLE account is just one single ABLE account nationwide. Number 13, incredibly important. Social Security is strictly defined, and I think based on what Congress wrote, that distributions coming out of a special needs trust are for the sole benefit of an individual. So if the individual is severely disabled in a wheelchair and wants to go to Disney World, clearly we can pay for the trip to Disney World for the individual and any related expenses. The question the trustees sometimes have is, well, is it the sole benefit to pay for somebody to push the wheelchair? It becomes a judgment call. I clearly think the answer is yes, but it does slow down trustees in making the determination. Whereas the ABLE account standard is, does the individual derive some benefit from the distribution? And clearly the individual pushing the wheelchair is providing a benefit to the person who has the disabilities. Number 14, method of determining disability is actually easier and easier standard under the ABLE accounts than it is under the Social Security rules. Number 15, what's really incredibly nice here, the money in an ABLE account is specifically exempt by federal law from creditors from bankruptcy and by state law from creditors. That's not true with special needs trust funds. The money in a first-party special needs trust are not exempt. Third-party money is exempt, but first-party special needs trust money is not. Number 16, if the special needs trust is disallowed, so you can have both, and I'm going to suggest in a few slides that yes, we absolutely do want to have both, that the trustee can use the ABLE account to provide some exempt income to replace the lost SSI funds while the special needs trust is on appeal. So Social Security has instituted a POMS, that's the Program Operations Manual System, that's their operating manual that's published online. You can just Google this and you'll see it. And that has specifically enforced and advised all Social Security staff that ABLE accounts are safe harbors and has some nuggets in it that's useful for us. One is that they've abandoned the sole benefit rule and they published in their POMS a clear indication that they're not going to apply sole benefit to ABLE accounts. They're applying the easier standard, just for some benefit. Okay, and I've given you here the IRS citations, and it's in the materials we provided. The second nugget is that we don't count distributions from an ABLE account as income. Okay, even if they're not, even if they're distributions, particularly for housing expenses. Anybody who's familiar with SSI knows that if a third party, including a trust, pays for rent or mortgage, food, water bill, electric bill, etc., it can reduce the individual's SSI check by what they call in-kind support and maintenance by up to 1/3. And so that's a significant loss. It amounts to about $3,000 a year. If instead the trustee of a special needs trust gives the ABLE account the money that the individual then who has control of the ABLE account uses to pay his rent or his electric bill, there's no deduction from their check, thus increasing their basic cash flow by $3,000 a year tax-free. Incredibly important. Okay. Onset of disability is another issue that is required solely because Congress didn't create ABLE accounts for everybody yet. There's a bill to make it a little bit more lenient. They said it's for any person whose disability began prior to age 26. The Social Security determination of what is onset is very technical and very difficult, whereas the IRS rules that have been issued with regard to onset are much more lenient than those for the special needs trust rules. I'm going to give you some examples of when you can use an ABLE account and do it without a special needs trust. Person gets an inheritance of $30,000, and it's at the end of this year. They have $30,000 of income in the month they received it, but they could put $14,000 into the ABLE account for their 2016 contribution, and January 1st put another $14,000 into the ABLE account, and they can keep up to $2,000 in their own account. So using an ABLE account, you avoid having to do a special needs trust, which is expensive and costs money to have a trustee handling it. So that's a very simple example. But think about it, a $500,000, $500,000 net personal injury award. So we get $200,000 cash from the award. We put $16,000 into ABLE accounts. And then we do a structured settlement monthly payment that's at $1,166, which times 12 is $14,000 a year, to the ABLE account for year 2 forward until all of the settlement money has been paid. That completely shelters then the funds from being counted, adversely affecting the individual's SSI and their Medicaid health insurance. Often, number 3, I'll get calls from churches or other concerned community groups who want to raise some money for a particular person or family, and somebody in that family may be receiving SSI and Medicaid benefits. An ABLE account is a perfect way to do that, Remember, the maximum is 14,000 in any one year, but it is a quick and easy way to shelter funds and continue Medicaid eligibility for individuals. Family support. You know, I had a situation with a young woman here in St. Pete who was living with her mom in her mom's condo. Mom died. The condo went to the sister, but the sister still had to pay HOA dues, property taxes, electric, etc. Her total SSI check is $733 a month. So the brothers started helping by paying funds to the sister. Well, cash money is subtracted from the SSI check. So she needs about $1,000 a month. They started giving her $1,000. She lost her SSI and her Medicaid. Instead, with the ABLE account, those same nice brothers who are helping out can fund the ABLE account, and the sister can use the money in the account to pay the bills that she has that are qualified disability expenses and not lose her eligibility. For some reason, I'm losing control here. There we go. Oh, one too many. I have an individual who's making about $50,000 a year and retaining Medicaid waiver benefits. She needs an aide to get her to work, to help her to do certain things at work, and our laws provide that that can happen. She wants to save money up to $55,000 to be able to buy a handicapped van from her salary that she gets. If she saves it in a regular account, she'll soon be over the maximum resource limits, and she'll lose her significant Medicaid waiver benefits. Instead, she can put the money, her savings, into the ABLE account. Alimony. Court orders husband to pay wife $1,000 alimony. He pays her. The $1,000 she gets is income counted by SSI. They subtract that from the $733 maximum payment they can make as an SSI payment. She's not eligible for anything, and she loses her Medicaid and other things. Instead, if the court assigns the payment that the husband's going to make and directs him to pay it to the ABLE account, that $1,000 monthly alimony payment has no effect on her benefits whatsoever. The same is true for child support. For a disabled child, the dad could pay the money directly into the ABLE account, and the mom can access the funds directly without having to go through an expensive pools or individual trust trying to get a distribution to pay bills. When not to use an ABLE account? Grandma comes to me and she wants to leave $1 million for a kid. Well, you can only put $14,000 a year into it. Why would I not want her to put money into an ABLE account as we're going along? Well, I would, but only a smaller amount of money at a time. Because we don't want grandma's money in a first part, ended up in a trust that's going to be in a Medicaid payback situation. So we want to create a third-party special needs trust, because the third-party trust has no Medicaid payback, and we get to have grandma name the contingent beneficiaries upon the death of the grandchild with disabilities. So that sets it up pretty well. But I'm going to want to make sure that my third-party trust has a clause in it that says that the trustee can fund annually or monthly a ABLE account so they can pass up to $14,000 a year into the direct control of the individual, who can then pay household costs without triggering the reduction in his check for paying for food and shelter expenses. Okay. ABLE accounts are subject to the Medicaid lien, and that's kind of a problem. So we never want to overfund, I said here the trust, but we don't want to overfund the ABLE account. We're really using the ABLE account in the third-party special needs trust situation as a way to increase disposable income for the individual, but we don't want to have so much there that it becomes subject to the Medicaid lien, because otherwise funds held by a third party are not subject to the lien. So we're wanting to, get the benefit of the best situation for the individual. With first-party special needs trust, this is where the person got the inheritance from grandma, but grandma just gave them $50,000. Well, that was kind of a disaster. We created a first-party special needs trust. It's going to have a payback. But what we want to do with that is to use the ABLE account to increase the SSI monthly check by $3,000 tax-free dollars a year by avoiding the in-kind support and maintenance deduction of 1/3 of his check. For smaller special needs trusts, we can just either put them into a pooled special needs trust, make sure they'll fund the account, or we can use the ABLE account directly, as I've suggested earlier. Okay. Drafting suggestions for special needs trusts. I think there's two choices here: mandating the trustee to fund the ABLE account annually, or permitting the trustee to fund the ABLE account. Mandating, I think when the person's perfectly competent, he's disabled, but he's not incompetent mentally, then I would definitely put mandating language into a trust. And in a situation where you might have a person who's addicted to drugs or alcohol, you might not want to do that, and then you might want to permit the trustee to have that discretion. And a third alternative is put in provisions to give power to a trust protector to later on require the trustee to fund an ABLE account or to not fund an ABLE account as things go on. So that concludes the legal aspect of it, but read the materials. I think you'll find them helpful to refer to. Thanks.
Wonderful. Thank you so much, David, for giving us that legal perspective. Now we're going to move on to the second part of our presentation, a financial perspective from Thomas Nurse. And Tom, the floor is yours.
Thank you very much, everyone, and welcome. First, I'd like to thank everyone across the state and across the nation that has worked so hard in implementing the Achieving a Better Life Experience law, and that Florida is taking the leadership, as David mentioned as well, is something that we can be entirely proud of. Like others, I am excited beyond words at the opportunities for economic freedom that are increased with the implementation of ABLE. And so what we want to really take a look at is how do we work at special needs planning perhaps differently than we do today? Can you move the slide down? I'm seeming not to have control. Oh, I got it. There we go. So what we want to try to do is take a look at kind of an overview, high-level view of special needs planning, and in order to do that, we really need to develop kind of a vision and a plan for the family. And when we start with the family because of a couple of things. Number one, the AARP has been instrumental in our country at really looking at on an ongoing basis long-term care. And to some degree, that's one of the biggest concerns we have with someone with special needs is how are they either going to be cared for or care for themselves with their special need. In the AARP study, they found that $470 billion a year was the value of what families provide in long-term care funding if they had to be paid. It's actually the largest source of long-term care funding is what families do on a daily basis. So this $470 billion number seems like a huge number, which it is. And by the way, it does not even include all the care that families provide for special needs children under the age of 18. As a father who's cared for a 25-year-old daughter with special needs, it does have a profound economic impact, sometimes in careers and futures and options and benefits and retirement funding and things like that. But it's a tremendous investment, and I'm proud of the outcome and continue to be committed. So why is special needs planning so important? Well, it's really important because as those of us that live with it or are part of it, or those that support it, we know that it poses very unique challenges to individuals and families, and unique meaning that it's not the same for everybody, and that we need to be able to vary our planning based upon the individual. The other thing that's really important to recognize is that as a foundation of planning, we want to use the philosophy is we're going to hope for the best. We're not diminishing a sense of the future. We want good things to happen, and our goal is to make those things happen. But we need to also plan for the worst. So graphically, metaphorically, we can envision the Titanic, the finest ship of its kind in the history of shipmaking, unsinkable. It was so unsinkable that when they planned it, they didn't really plan for it to sink. And as a result, when it did sink, they didn't have enough lifeboats. Their planning was inadequate, and we know the rest of that story. So when it comes to hoping for the best and planning for the worst, we want to learn the valuable lessons of the Titanic by really having engaged dialogue, conversations, planning strategies to say, how does this thing work? How does it work when I'm no longer here to provide care? How's it going to work for me as an individual, as maybe some of the external supports that I'm getting go away, those types of things. And when you're looking at it from a financial planning perspective, one of the things that we really do as a cornerstone of planning is look at needs, concerns, and also the protection of assets. So as the AARP study reflects, the family care, what families do every day, is considered the most valuable asset in long-term care. So that asset, what happens when it goes away, we need to find ways to supplement or replace that care, and that's where a lot of the dialogue around special needs planning comes into, is how does this thing work over time? How does it work over life's cruise? Specifically, there are three really critical elements to special needs planning. First and foremost, in a person-centered perspective, not about me, without me, it's a vision of the individual and the family. We know that the spectrum of disabilities and special needs is vast. There are people that have profound needs for care in all elements of life, and there are some that may have, for instance, significant physical disabilities, have intellectual capacity, and somewhere in between. There is a wide variety. The family, if you ask, knows more than anybody else about what's going on. They have the greatest concerns about what's going on and what the future is going to be. And so engaging the family in a conversation and a vision of the future is absolutely critical. For instance, in our own family, we wanted it that our daughter had choices going forward, knowing that she has significant physical needs and accessibility needs and environments that need to work for her. We wanted her to always be able to live with people she chose to and not be forced to live with people she didn't choose to live with. Well, that's a nice thing to say, but it also requires, if you want to be part of that solution, you very well may need to be part of the discussion about that. How will that work and how will it be paid for? That's overlaid with all the incredibly critical information that David shared in such a concise way, and it really demonstrates how critically important the legal aspects of this planning is. David gave numerous examples of scenarios where special needs planning really is critical in choices and options and opportunities and cost effectiveness. And it's one thing to talk about it. It's a completely different matter to actually put into place a legal plan with documents and advance directives, healthcare surrogates, family trust, special needs trust, all the dialogue about how will it work. Embedded into planning, the legal part of it provides an incredibly powerful foundation for these things to go from being a hope to being a plan. And then a vision and a legal plan without a way to pay for it can lead to great disappointment, sadness, and also problems. So sitting down and looking at the economics of the situation and what the options are or may be in the future, and that may extend beyond the immediate family. Routinely, we see in talking to clients, their parents are watching their son and daughter struggle with the care of their child with a special need. So 3 generations of conversations, and many times the parents are struggling with the day-to-day, are challenged by the impacts on careers and time and sleep and health and economics and emotion and just tremendous change. And many times grandparents struggle with how they can help and what they can do. And we have found many times engaging that multi-generational conversation can be critical, not only for the individual, but for the entire family. And I think that's a critical part of pulling together planning. So some of the issues that are become part of this financial planning and part of the engaging families in an in-depth dialogue and a plan is there's always been concerns. There's concerns about what happens at the age of 18 and happen the transfer of rights and the age of majority and guardianship options and how is all that going to work. That's very much of a legal issue, but it's also a philosophic issue. And, you know, there is a tremendous emphasis and move forward towards self-determination and being able to have freedom of choice and independence and maximizing that potential for an individual. Another significant issue is funding of quality of life. There are no public funds that help pay for things like, you know, cable TV or you know, a cell phone or travel or entertainment or some of those things that when we talk to families, their big concern is I want them to be not only safe and healthy, I want them to be happy. And that happy is where quality of life comes in, and those many times are not, most of the times are not a publicly funded thing. A very, very significant concern is the access to health care, but primarily the access to long-term care. One of the challenges with individuals with disabilities is that if you have a disability or a special health care need, it's very, very unlikely that you can purchase a long-term care insurance policy. You will be disqualified because of your existing condition. So for many people, Medicaid has become the long-term care program, and med waivers providing additional options in long-term care. But the premium for long-term care has been poverty, less than $2,000 of assets in your name. That's where one of the most exciting elements of the ABLE is the ability to not have to be poor and to not be able to dream of a future of saving for a home and a car and for things. That is gone. With an ABLE account, that first $100,000 doesn't even impact your SSI. The issues of coordinating complex systems of supports that are intended to help government programs of Medicaid and schools and VR and transportation and housing and health care, it's complex, and many times those programs are not don't always have the ease of use and the coordination across that. And there's certain skills that are required to be able to make things work together. David articulated beautifully about the issues of asset and income limits under the SSI, and the SSI is the poverty cash subsidy that because you're so poor you also now qualify for Medicaid, and that's where again utilization of the ABLE account, special needs trust can be a critical element of how do you keep that long-term care that is beyond your means to fund yourself. Actually looking at the idea of saving and accumulating wealth and discussions about inheritances and having discussions about that and planning for that and wanting to do that is what a lot of families want to do but don't know how to do. And clearly having dialogue both from a legal and financial and an integrated approach, combining those conversations is critically important. We also see an awful lot of families where siblings are concerned, are eager to help, or somewhere in between. Yet maybe many times they have not been engaged in the conversation about how's it going to work. There may be assumptions but not plans. So having a legal plan and a financial plan for how that you could care for your brother or sister or whoever once their parents are gone, that who's on deck conversation, it's best to have those in advance to get clarity, to know expectations for the person to be able to say, I really can't do that or I can do that, and to better understand what your options are on that. And clearly, having freedom of choice is tied together significantly, those that have money have more freedom to choose than those that don't. And again, that's where ABLE becomes an exciting option. So when we look at why an ABLE account or a special needs account are so important, I think David articulated that beautifully. He went into detail about the three types of trust. And this is a visual that really begins to show the idea of integration, and that when you begin to look from a person-centered approach with the engagement of moms and dads and brothers and sisters and guardians, aunts, friends, grandparents in that inner circle of love, and there is then engaged dialogue about hopes, dreams, future concerns, how's this all going to work, and it then begins to be formalized and wrapped into a legal plan, and that there is a financial plan. And when you look at it from a financial perspective, programs and services and supports are assets. They are money. They are of value. And again, when we go back to life with disabilities is more expensive, family care is the most valuable part of the whole system, that there are programs, services, and supports that are intended to help the individuals, and they may prove to be complicated to access and integrate, but when you do that, you may also require the use of a special needs trust. You may see that the ABLE account provides options of financial flexibility, independence, and access, and greater abilities to have self-determination. This is an image of just a sample. Creating this on an individual basis, like all planning, it is very individualized. So today's dialogue was not specific financial advice, but more of a conceptual understanding of what is possible and what can be done. It's really important that in opening an ABLE account, on the back side of their booklet, it says the following in the booklet. This information is for general information purposes only and does not constitute tax or investment advice. Carefully consider the objectives, risk, charges, and expenses before investing. It is possible to lose money by investing in this program. Please read the program description and participant agreement. What that says is seek help of your financial professionals because they can give you advice on what to do and how to do this. Be knowledgeable, read about what the investments are, have goals and objectives to do this. I strongly urge people to read the program description and participant agreement and to be able to utilize the ABLE account for the benefits that have been described today, and to realize that this is a earth-changing moment in disability culture in the United States. Instead of moving from a strictly poverty-based approach to benefits, there is a recognition now that the economic independence of the individual, the better they can do, the more options they have, the more they have self-direction and self-determination. So I encourage folks to ask questions, learn more, be engaged, and I really do thank you for the opportunity and look forward to being part of the question and answers. Thank you.
Great. Thank you, Tom, so much for taking the time to go ahead and participate on this presentation. I appreciate David being on as well. This is the time where we're going to take questions from the audience. So there is a questions box on your screen that you should be able to go ahead and type in your questions, and we'll be able to answer those. As you're thinking of questions, I'm going ahead and post another poll just to see if you're interested in joining the ABLE United community. This will allow us and those that are on the webinar to receive informational updates from ABLE. Also, you'll be aware of any upcoming webinars and things that are happening in the disability community. Meanwhile, while you're filling that poll out, also think of your questions, which we'll be answering here momentarily. All right, I'm going to go ahead and begin with answering some of the basic program-related questions. Can an individual with a disability contribute their own income to an ABLE account? And that is correct. Although it will not shelter that income as earned income, it is an asset sheltering financial tool, so you'll be able to put money, the individual put their own money into an ABLE account, but it still will count as income towards that individual.
John, I'd like to add that there's a previous webinar that is on the Able United website that was also recently done that really gave some great insight on how an individual could be able to explore budgeting and how they may be able to work that kind of contributions into their planning.
Wonderful. That's correct. Can I transfer money from a 529 account, which is a college savings account, to an ABLE account? And the answer to that is currently no, even though they're based on the same IRS code 529. ABLE is 529A. Currently, there is federal legislation to hopefully change that. This video will be available online. It will be posted on our website, so check our website under resources to view prior webinars as well as this current webinar. I have a question here for David. We have set up both a third-party special needs trust and an ABLE account. Could you restate the wording that should be in a special needs trust account? Do you have suggested language?
Correct. And so far, the person who posed the question has done everything exactly correctly, because I think it's important to have an ABLE account working with the third-party special needs trust trustee. The wording that I would suggest doesn't have to be too fancy. It's just something that either, and this was the choice that I presented, requires the trustee, the person in charge of the third-party special needs trust funds, either requires them to fund the ABLE account every year, but if you're concerned about the person with disabilities that's a designated beneficiary of the ABLE account and their ability to correctly manage money, and if they're in charge of those funds and for some reason due to immaturity or due to addiction to alcohol or drugs or something, you may not want them, then the language I would suggest is giving the trustee the option, the trustee of the third-party special needs trust, the option to fund the ABLE account. So it's nothing fancy, just a simple statement like that in the trust document. There's no magic language that you have to follow.
This is Tom. I'd just like to also add that it's really important to know that the trustee either does the financial management of the assets in the trust or delegates that to a financial advisor like myself. And the planning to fund of a ABLE account from a special needs trust may also require looking at the strategies inside the trust and how you're going to sustain those distributions and where's the source of money going to come and how does that work within the overall financial plan.
Wonderful. I have another question. Can funds be moved from a pooled trust to an ABLE account?
I'll take that. Yeah, the statute creating the ABLE account says that any person can create an account and can fund the account. And then the word person is defined in the Internal Revenue Code to include a trust. In the written materials that I provided, I've given you the actual quote of the definition of person and the citation in the IRS code where you can check it out yourself. But a trust, and it doesn't limit it, the word is not limited to just certain types of trusts. Pool trust, individual trust, third-party trust, doesn't matter. A trust can fund an ABLE account.
Great questions. Here is a good question for Tom. What are the key questions I need to ask my financial advisor?
If you currently have a financial advisor, I would ask them to look how has my child's special needs been integrated into our financial plan? Are you able to collaborate with others? So for instance, many times there are expertise that can be brought in as part of planning that may be focused specifically on benefits and resources and how that integrates together. And also, you want to see if they have experience working with special needs attorneys or special needs within the special needs community, because that knowledge is critical as far as being able to see how you manage the assets that may be on just the money inside that the person is managing, but also the other assets that influence how that money is managed.
John, if I could, I just wanted to add something to the first question that you were presented, which is, can the person with disabilities put their funds into an ABLE account? And let me make it clear, if the person with disabilities has the money in their control, and then they put it into the ABLE account, they still are charged with having income that month. So if somebody just gives the individual $500 in the month of November, and now he's got $500 and he wants to put it into the ABLE account, he's already had unearned income of $500, which the next month will be reported to Social Security, and the following month will reduce his check from $733 down to $533, or excuse me, down to $233 if it's a $500 gift. The better alternative is to have the third party who wants to give $500 to the individual put the $500 directly into the ABLE account. Secondly, we have certain opportunities to irrevocably assign income so it never comes into the hands of the individual. And that was my examples with child support payments and alimony payments. But it would also be with with settlement of personal injury cases where you use a structured settlement annuity that pays for many years, or perhaps even the lifetime of the individual, an amount that's underneath the $14,000 per year. And that needs to be, all three of those need to be irrevocably assigned by a court. So it's not the individual receiving that $1,000 a month child support in their own hands and then themselves putting it into the ABLE account. You want it to go directly from the payor, the person ordered to pay support, the insurance company that's paying the structured settlement annuity, the spouse who's paying the alimony, irrevocably assign the payment directly to the ABLE account. It's a very important distinction to avoid the individual who has disabilities losing their SSI.
And I must comment that frequently divorce is an element of disabilities in families, and not as often as we would hope. The courts may not necessarily recognize, or the council may not necessarily recognize the complex needs of integrating the special needs elements when talking about things like child support versus lifetime support for a child, and those kinds of elements, and where that money comes and how it's going to be able to be assigned has a big impact also on the financial plan for that family moving forward.
Wonderful. And I have a couple questions regarding the Florida residency requirement, whether it be a military family that is looking to move out of state, or if somebody is transferring funds from out of state. The basic requirement, the eligibility requirement for a Florida resident is at time of application. We don't require any kind of documentation to upload or prove that you're a resident. You self-certify that you reside here in the state. So that is the only requirement. If you move out of state, you can take the Able United account with you. There is another question regarding a program. Is there a waiting period to withdraw from an ABLE account? No, the only waiting period is for funds to clear. So if it's electronic transfer, it usually takes a couple days. If a check is sent in as a deposit to a secure lockbox, that takes a little bit longer to clear. Speaking of making deposits into your Able United account, we do offer a gift certificate on our website under resources. You can download this form and it gives you all the necessary information you need in order to have family or friends to contribute to your account. And that is our time for today. I want to thank you, Tom and David, again for taking their afternoon to present with us on this webinar. Once again, this webinar will be available on ableunited.com. The attached handouts as well as this presentation will be emailed out to those individuals who have attended or signed up for the webinar. And for those that had questions that were not answered, we will do our best to reach out to you after the webinar. And David, Tom, thank you again for your time. And that concludes our webinar at this time.